Welcome back to the deep dive. So, you've handed us a pretty dense stack of sources this time. We've got legal analysis, we have statutory summaries, case law, all focused on one incredibly volatile intersection.
It really is. We're talking about firearms possession in Florida, but specifically looking at the rules imposed by private residential authorities.
Right. So, HOAs, condo boards, property managers, that kind of thing.
Exactly. And it's an area just saturated with emotion and, frankly, a lot of political noise. I mean, the common narrative around gun rights, it almost always focuses on these huge, visible legislative battles.
Sure, you see the headlines about open carry bills, you watch the political theater down in Tallahassee, and social media just lights up over any big constitutional challenge.
Right, and people get really invested in that fight.
Okay, let's unpack this. Because what your sources are arguing is that paying attention only to those big state-level battles is, well, it's a fundamental distraction.
It is. They contend that the real threat to lawful firearm possession isn't that visible legislation at all.
It's a quieter, more dangerous trend, that's the quote. And it's happening inside residential communities, hidden in the declarations and bylaws of your own neighborhood?
That is the core argument. And here's where the mission for this deep dive gets really specific. This wave of private regulation, it's not aimed at criminals. It's not aimed at prohibited persons.
Okay.
The rules are being drafted with one group and one group only in mind, the law-abiding gun owner, the person who has, otherwise fulfilled every single state requirement to own that firearm.
Wow, okay. That distinction changes everything. So our mission here is to cut through all that noise, ignore the political posturing for a minute, and deal strictly with the reality of Florida contract and property law.
We have to.
We need to define the actual legal boundaries so you, the listener, can kind of inoculate yourself against bad advice, intimidation, and frankly, unnecessary compliance with rules that might not even be valid.
Exactly. And the root of the problem, as these sources really detail, is the inherent complexity of Florida's firearms laws. They're not simple.
And when a law is intricate and nuanced like that,
It creates ambiguity. And that ambiguity is an opportunity. It's an opportunity for, say, an overreaching HOA or a risk-averse condo board or these big corporate property managers.
and you mentioned developers too.
Oh, especially developers. They're trying to, quote, future-proof their liability.
Wait, hold on. If the law is complex, why does that empower the HOA? I mean, shouldn't complexity just lead to paralysis? Everyone's afraid to act?
You'd think so, but no, not at all. In this context, complexity empowers the entity with the deeper pocket.
The one with the lawyers on retainer.
The one with the hired legal
Exactly.
counsel.
Yes.
Exactly. They draft a restriction that sounds really official, legally solid, knowing full well that the average resident is just confused. They're confused by the overlapping layers of state law, local rules, private contracts.
So they just comply.
They comply. Rather than pay thousands of dollars to challenge a rule, they just go along with it. So the homeowner gives up ground without ever putting up a fight, all because the law just isn't intuitive.
So clarity is the foundation of any defense.
It has to be.
Okay, so this moves us right into examining the fundamental threat here, which the sources call, pretty bluntly, legal illiteracy. And it's a powerful claim. They say that rights don't just vanish overnight. They are, and I'm quoting here, regulated to death through ignorance.
It's a harsh way to put it, but it's necessary. Think of it like a slow erosion. A gun owner loses ground not because the legislature came in with some massive sweeping ban,
No.
but because they accepted 20 small little administrative restrictions imposed by their HOA board over the course of a decade.
And the sources are really clear about where this danger comes from. It's when gun owners don't understand the difference between three very specific and very distinct categories of legal authority.
Right. You absolutely have to be able to clearly delineate between them. First, you have state law.
Okay, so that's the actual statutes passed by the Florida legislature.
Yes. These are the laws that define where you can carry, who can possess a firearm, and they establish that principle of statewide preemption, which is huge.
Meaning local governments, cities, counties, they generally can't make their own gun laws.
For the most part, no. Okay, so that's bucket number one. Bucket number two is private contracts. This is your HOA declaration, your condo bylaws, the rules and regs you agreed to or the previous owner agreed to when the property was purchased.
And the third bucket?
The third is constitutional limits. This is what dictates what any entity operating under state authority, and that includes a private one like an HOA can ultimately do, especially when it comes to fundamental rights.
You know, the confusion here is really understandable, though. I mean, If the HOA's lawyer sends me a letter saying Rule 3.5 bans carrying a firearm in the pool area,
Right.
I don't know off the top of my head if that's a valid contractual obligation or if it violates state preemption or if it's just, a meaningless piece of paper.
Exactly. And when that confusion exists, the source material points out that owners lose ground without ever setting foot in a courtroom. They just comply because a board member says they have to.
And they're leveraging the authority of that contract.
They are. And that compliance, even if you're doing it under duress, often ends up validating the rule in practice. It makes it exponentially harder to challenge legally down the road.
So all the focus on the big statewide headlines, the constant debate over open carry, it's actually distracting us from these hyper-local vulnerabilities.
That's the problem of misdirected focus.
We're looking at the big visible enemy while the quiet administrative enemy is already inside the gate.
It is. I mean, state law is crucial, don't get me wrong. But for the vast majority of law-abiding gun owners, the most immediate, the most tangible, and the most enforceable restrictions on how they live with a firearm are coming from these private entities that govern where they live.
They're the ones rating the parking rules, the pool hours.
And increasingly the firearm restrictions.
And your sources confirm this isn't just a theoretical worry. These regulations are being pushed through right now.
Oh, yeah. Often using generic, corporate-drafted boilerplate language that gets copied and pasted from one community to the next.
And the complexity of the law is the shield they use to do it.
It is. They assume, and they're often correct, that the resident will just assume the private entity's rule must be valid because it's printed on official letterhead.
Which is why legal illiteracy is the quiet attack.
It's an administrative victory, and it's achieved through a calculated gamble on homeowner inertia.
All right, let's just get to the foundational question then, the one everyone wants answered directly. Can HOAs and condos regulate firearms in Florida?
Okay, the concise and crucial answer from the analysis is yes, but not without limits.
Yes, but...
That is the vital starting point. If you start from a position of, no, they can't do anything, you risk non-compliance that could get you fined or drag you into a legal battle you don't need.
But if you start by saying, yes, they can ban everything, you panic and you just surrender your rights.
Exactly. The truth, the entire legal battle, lies in those three words. Not without limits.
Here's where it gets really interesting, because to understand those limits, we have to understand the source of their power in the first place.
To understand the limits, you have to define their legal identity. And HOAs and condominium associations are legally defined in Florida as creatures of statute and contract.
Okay, that sounds like lawyer speak. Creatures of statute and contract. What does that actually mean, and why is that different from, say, a city government?
It's a critical difference. It means they are not a sovereign power, a city council, the state legislature. They have what's called inherent police power, the power to regulate for public health, safety, welfare.
The power to criminalize behavior.
Right. An HOA has no inherent power, zero. It only has delegated power, which is granted to it by the state legislature through statutes like Chapter 720 for HOAs or 718 for condos to manage shared contractual property interests.
So their power is conditional. It's not absolute. They can regulate the terms of the contract you signed.
Yeah.
But they can't just create new laws out of thin air.
Precisely. If they try to act outside the terms of their own contract or outside the scope of those enabling statutes, they're acting ultra vires, which literally means beyond the powers.
And that action is voidable.
It is. So for you, the listener, this means the HOA can probably fine you for painting your house the wrong color. That's a contractual property interest. But they can't arrest you or unilaterally make concealed carry illegal, because that's a sovereign state interest.
Okay, so within those conditional boundaries, what are the legitimate areas they can regulate?
Well, first and foremost, they can regulate conduct on common property. This is key.
The shared lobby, the community pool, the clubhouse.
The tennis courts, the parking lot, yes. They can enforce rules there. They can also enforce what the courts call reasonable rules tied to safety and use. And of course, they can amend their declarations and bylaws, but only if they follow the established procedures and stay within all those legal and contractual constraints we've been talking about.
Let's focus on that phrase, reasonable rules. Can you give me a tangible example? The difference between a rule that's legally sound and one that steps way too far.
Sure. A rule that would likely pass scrutiny might be one that requires any long gun being transported from a vehicle to a residential unit to be placed in a fully sealed, non-transparent case.
Okay. Why is that likely reasonable?
Because it's arguably tied to safety and conduct in a common area, the parking lot, the hallway. But a rule that steps too far would be a blanket prohibition on the storage or possession of a firearm inside your own locked unit.
Or one demanding residents inform the board every time they buy a firearm.
Exactly. The first rule regulates conduct in a shared space. The second one attempts to regulate private possession inside the home, which is highly, highly protected under Florida law.
And the ultimate test of their authority, as the source material explains, is this reasonableness standard that Florida courts apply. So why does this one judicial test become the key battleground?
Because it forces the HOA to prove its restriction is legitimate, not just arbitrary. The court is going to ask, does this restriction bear a reasonable relationship to the community's stated health, safety, or welfare goals? Or is it arbitrary, capricious, or discriminatory?
And for something like the right to keep arms.
For fundamental rights, the courts will apply a very high level of scrutiny.
That's a crucial term. Very high level of scrutiny. What does that actually look like in practice for a homeowner trying to push back?
It means the board can't just stand up and say the word safety. They have to substantiate it. The analysis is very clear on this. Blanket firearm bans are legally vulnerable, especially, and this is the key part, if there are no prior incidents to justify the restriction.
So the absence of a problem is your best defense against an arbitrary rule.
It is. If the board hasn't had a single documented gun-related safety issue in a decade, their sudden claim that they need a sweeping new ban on carrying in the common areas starts to look like an emotional reaction to a headline, not a necessary safety measure for this community.
So as the resident, my intelligent pushback isn't yelling about the Second Amendment at a board meeting.
No.
It's calmly asking, can you please show me the documented incident reports that necessitate this fundamental change to our contract?
Absolutely. You use their own legal standard against them. This is discipline, not defiance. If they cannot provide data to support the alleged safety need, the rule is highly likely to fail the reasonableness test in arbitration or in court.
Okay, let's pivot to what you call the private property myth. This is where so many people, even some instructors, get it wrong. They argue that because an HOA is private, it can do whatever it wants, that constitutional scrutiny doesn't apply.
And the sources are emphatic that this is explicitly false.
Why?
It's a sophisticated point, but it's critical. While an HOA is not a government in the traditional sense, it's also not treated like a single independent private homeowner. Why? Because they are given power by the state to operate.
And that link to the state, that's what brings constitutional scrutiny into the picture.
Precisely. The sources lay out 3 reasons. 1, they're created under Florida law. 2, they operate under state-granted authority to do things like collect mandatory fees, place liens on your property, and enforce regulations. And 3, they govern fundamental aspects of your residency and your property ownership.
So because the state empowers them to act like a quasi-governmental body for the residents.
They cannot simply ignore constitutional considerations or violate clear public policy.
Which means a court has to do that complex judicial balancing act you mentioned earlier. They're balancing the residents' individual right to arms against the association's contractual property interest in maintaining orderly common areas.
Yes, and a common way they do this balancing is by looking at precedent and historical use. If a new rule suddenly imposes a severe restriction on a long-held right, especially one that's protected by the state constitution, the burden of proof falls very heavily on the HOA to justify why that restriction is suddenly necessary.
And a sudden sweeping ban without any documented justification.
That's exactly the type of regulation that courts are designed to question.
Okay, let's shift focus to practical competence. We need to be precise with our language here, and the sources say nothing is more important than the distinction between possession versus carry.
It is the most critical, practical distinction, full stop. For any law-abiding owner in a shared residential setting, this is it. Confusion right here is what leads to legal jeopardy, fines, and potentially very bad interactions with law enforcement.
So let's map the terrain. The sources break down a resident's interaction with their firearm into 3 distinct zones.
Right. So Zone 1 is possession inside a lawful residence. This means inside your specific condo unit, your townhome, your single-family home. This area, under Florida law, holds the strongest protection for the gun owner. The state is extremely protective of your right to keep and possess firearms within your own home. An HOA has almost no legal avenue to regulate lawful possession inside your 4 walls.
Okay, that's Zone 1. What's Zone 2?
Zone 2 is carry in common areas. This is the parking lot, the shared garage, the elevator, the hallways, the pool, the clubhouse. This is the area that is most subject to reasonable HOA regulation, provided Again, that they meet that reasonableness standard we talked about and don't violate state law.
And Zone 3, which you said is often overlooked.
Yes. Zone 3 is the public sidewalks and roadways that might run through or border the community. These are governed exclusively by Florida state law. The HOA cannot prohibit lawful carry on a state-maintained road or a public right-of-way just because that road happens to run through their development.
So you have to know exactly where the HOA's contractual jurisdiction ends and where state jurisdiction begins.
You must.
The danger then comes when people confuse Zone 1 and Zone 2. And this leads to that kind of sloppy advice we see all over the internet, like the infamous instruction to just conceal it when you're walking from your car to your front door.
That sloppy advice is unbelievably risky, and it's because people fundamentally misunderstand the legal definition of concealment in Florida.
It's not about your intent.
No. Concealment is defined by visibility, not by the owner's intent or how hard they were trying to cover it. A lot of people assume if it's holstered under a loose shirt, they're good to go.
But the reality, as detailed in the sources, is that if any part of that firearm, or even just the outline of the firearm or the holster, becomes visible, say you lean over to grab groceries or a gust of wind blowed your shirt up,
it instantly constitutes open carry. And if you are open carrying in a place where you are not statutorily permitted to do so, you have broken state law.
regardless of what the HOA rule says.
The HOA rule is secondary at that point. The state law is paramount. And the sources stress this over and over. Training matters, precision matters, language matters. You have to know the precise line of visibility to remain compliant and avoid a really bad day with law enforcement or, a zealous neighbor who decides to call the police.
Okay, let's tackle the disclosure myth next. This is that claim you see online that since Florida doesn't require gun registration, no one, not the board, not a neighbor, nobody can ever lawfully ask you or require you to give information about your firearm ownership.
And the sources explicitly state that this advice is recklessly false.
Why?
Well, while it's true Florida has strong protections against a general government-run registration system, that does not mean you are immune from disclosure under all circumstances. That blanket advice comes from confusing a constitutional right with total contractual or legal immunity from ever having to talk about it.
Okay, so if my nosy neighbor asks me in the elevator, hey, do you own guns? I have no obligation to answer that.
Of course not.
But in what context can disclosure actually be legally required?
There are a few very specific legally defined contexts. For example, under a court order. If you're in a civil dispute or a divorce proceeding, a judge can absolutely compel you to disclose your assets, and that includes firearms.
Okay, what else? Second, in certain employment or contractual agreements, if you sign a rental contract that includes a legally valid clause about, say, mandatory disclosure of how you're storing it for safety reasons, you may have contractually waived your right to silence in that very specific context. And third, and most practically, during lawful law enforcement encounters under defined conditions, especially if it relates to a search or an immediate safety concern.
So the recklessness of advising people to just give a blanket refusal
Yeah.
is that it sets the owner up for an immediate legal confrontation.
Yes.
In scenarios where cooperation might be legally required or at the very least professionally advised by an attorney.
It just creates unnecessary friction. The sources stress that the smart gun owner understands when to speak, when not to, and why. It's about being legally strategic. Knowing your rights means knowing the difference between the HOA board, who you can generally ignore, and a lawful demand for information from a court, which you ignore at your own peril. All right, moving into the current environment, we need to understand the motivation behind this whole regulatory wave. Your sources characterize the surge as being primarily defensive, not ideological.
That's right.
And that suggests the motivation is driven more by money and risk mitigation, not necessarily anti-gun politics.
It is fundamentally a business strategy that's disguised as community policy. I mean, if this were purely ideological, we would see unified political action. But we don't. Instead, what we see is these localized, scattered restrictions that are driven by an institutional fear of liability.
The sources point to 4 primary drivers that work together.
Yes, 4 main ones.
Let's start with the developers. Developers fear lawsuits. How does a restrictive clause in a condo declaration help them with that?
Well, developers, or the association management company they eventually hand the keys over to, they want to minimize what's called tort liability. If a severe incident happens on the property, even one involving illegal conduct, the victim's legal team will inevitably look for anyone with deep pockets to sue.
And they'll argue the developer or the board was negligent.
They'll argue they were negligent because they didn't take reasonable steps to prevent the incident. So by drafting this overly broad, restrictive language into the initial documents, they're trying to establish a paper trail that says, hey, we did everything in our contractual power to ensure safety.
It's an attempt to future-proof their liability.
That's the term they use. They're using the rule book as a shield in a future civil court case, even if that rule book is legally tenuous under state law.
And they shift the cost of fighting the rule onto the resident.
Exactly. They'd rather have you fight their rule than have them fight a multi-million-dollar liability lawsuit.
The second driver is closely related. Insurers demand risk mitigation. This feels like the ultimate financial lever.
It is often the most immediate trigger for a board to take action. The insurance carriers that provide property and liability coverage for these large residential properties, they're tightening their underwriting standards.
And they see communities without firearm restrictions as a higher risk.
A much higher risk. So if the insurer demands that specific restrictive bylaws be adopted, say banning the carry of firearms in the pool area, the board, which is fiscally and contractually obligated to maintain insurance for the community, will often comply instantly.
To avoid huge premium increases or losing coverage altogether.
It's regulation by the private financial sector. It's that simple.
Okay, third, we have the emotional factor. Boards react emotionally to national headlines.
Yes, this is a big one. When a high-profile tragic incident occurs somewhere in the country, the board gets inundated with calls and emails from residents demanding that they do something.
And that reactive panic leads to
Hasty, overly broad restrictions that have zero basis in that community's actual safety history and, as we've said, often fail the reasonableness test. They're acting to soothe resident anxiety, not to solve a documented legal problem in their own backyard.
And the final driver is the council itself. Lawyers draft overly broad restrictions just in case.
It's standard legal practice for an attorney drafting these governing documents to be extremely conservative. The safest advice for them to give their client, the board, is often to restrict as much as possible.
Not because they think it's legally sound.
Not always. But because it pushes the burden and the cost of challenging that restriction onto the residents. It's a proactive legal maneuver to protect their corporate client.
Which leads to that tragic process of erosion we started with. These restrictions become permanent not because of legislation, but because the gun owner remains silent and fails to push back intelligently.
They just become accepted norms.
And once a restriction is in place for 5 or 10 years without a challenge,
it gains a kind of de facto legitimacy. It becomes much, much harder to overturn later. And that just emphasizes why the initial pushback, grounded in legal fact and discipline, is absolutely vital.
So what's the action plan? If I'm a resident and I'm facing this, the source material frames the pushback as a call for discipline, not defiance. We need specific, actionable steps.
The first, most foundational step is also often the most boring one.
Let me guess.
Read the declaration and bylaws. Not the angry email blasts from the board, not the minutes for the latest meeting, but the actual foundational documents. The declaration is the constitution of your community. It's the contract you signed. You have to know what the original agreement actually permits.
And the second step is highly strategic. You need to identify when the rules were adopted and figure if they changed any prior allowances. Why is the adoption date so critical to a legal challenge?
Because it determines a standard of review a court will use. If that restriction was already in place when you purchased the property, challenging it is exponentially harder. A court might argue you willingly accepted those contractual terms.
You bought into it.
Right. But if the rule was passed after you moved in, it's an amendment. And that amendment is subjected to a much higher level of legal scrutiny under that reasonableness standard. Identifying the date is how you prove whether you're challenging an existing contract term or an arbitrary new change.
Okay, third. The resident must actively document the absence of incidents. This is to counter those arbitrary safety claims. We've established this is the core of that reasonableness defense.
You're creating a paper trail. You're showing that the HOA is trying to solve a problem that doesn't actually exist within your community. If you're going to challenge the rule, you need to bring evidence that contradicts their claimed need for enhanced safety.
Fourth, and this should go without saying, but it really needs the emphasis, seek qualified legal counsel.
And not just any lawyer, not a generalized real estate lawyer, but counsel who specializes in this niche intersection of Florida firearms law, corporate association law, so chapters 718 and 720, and property law. The complexity here requires very specialized knowledge.
Social media advice is not going to cut it.
It will fail you, especially when your money and your property interests are on the line.
Fifth, the sources advise residents to support legislative clarity rather than just emotional escalation.
Right. If the law is ambiguous, legislators can clarify it. They can strengthen state preemption specifically to guard against private contractual overreach. Supporting those efforts provides a systemic, long-term solution that is infinitely cheaper and cleaner than years of complex, individualized litigation against your own board.
And finally, which I think brings us to the ultimate point here, train with instructors who understand Florida law. Your rights are only as strong as your practical legal competence.
This is the capstone of the entire analysis. The sources are adamant that rights are preserved by competence, not by noise, and that training has to extend far, far beyond just marksmanship.
Okay, let's dedicate some time to this because this is where the actionability for you, the listener, really lies. Training has to go beyond tactics. Let's detail what the sources say is crucial knowledge, starting with lawful carry boundaries.
Your training must instill precision. Precision regarding visibility and location. Do you know the exact statutory exceptions that allow for open carry in Florida? Do you know the precise legal consequence if your firearm is momentarily visible in the parking garage while you're getting luggage?
If you don't know the difference between getting a fine from the HOA versus being charged with a misdemeanor by the state,
Then your training is insufficient. It's that simple.
next is use of force boundaries. This is often the most dangerous area for a legally ill-informed gun owner.
You have to understand the boundaries of deadly force, specifically in the context of Florida's stand your ground law. But critically, you also need to understand how the legal definition of dwelling or curtilage applies in a complex residential structure like a condo building.
Right. Does your defensive perimeter end at your front door, or does it extend into that common hallway right outside your unit?
Understanding those specific legal definitions could be the difference between a clean legal defense and spending years in prison.
Third, and this is the one that can be financially devastating, civil liability exposure.
So many gun owners focus only on the criminal law. Did I commit a crime? But even if your use of force is found to be perfectly justified under the criminal statute, you can still face a ruinous civil lawsuit from the person you stopped or from their family.
And your training needs to cover that.
It has to cover how actions you take before or during the encounter things you say, or maybe failing to comply with some non-gun related safety rule can be used against you to prove negligence in civil court. This is the expensive, brutal reality of self-defense.
And the final piece is understanding the real-world consequences.
This is everything. It's the protocols for interacting with law enforcement right after an incident, knowing what to say and what not to say. It's understanding the non-criminal administrative consequences, like the potential loss of your concealed carry permit during an investigation, even if you're ultimately exonerated. Legal competence is recognizing that every single action has cascading legal and financial consequences.
The ultimate point the source makes here is that the fastest way to lose your rights is to listen to people who misunderstand the very law they are quoting.
Exactly. Florida gun owners need better information, not just louder voices. If your source of advice can't accurately distinguish between Chapter 718 for condos and Chapter 720 for HOAs, or can't articulate the difference between criminal concealment standards and contractual restrictions on carry, you're relying on a house of cards.
Yeah.
Your personal defense strategy has to begin with intellectual discipline.
We have completed the deep dive. We've established the clear legal lines that separate state authority from private contract, and we've shown precisely how the complexity of Florida law is, well, it's being exploited by private entities to restrict rights quietly through the contractual fine print.
Yeah.
We've defined what a creature of statute is, detailed the power of that reasonableness standard, and clarified the absolute necessity of distinguishing between possession and carry.
And the takeaway here really is a call for strategic calm. This is not about panic. No one is banning firearms statewide tomorrow. But the history of rights suggests that they erode slowly and contractually when they are not defended intelligently. It happens one unchallenged bylaw at a time. The defense of your right really starts at your closing table.
So what does this all mean? If you are a firearm owner in Florida and you live in any form of private residential community, you owe it to yourself to fully internalize where the law actually stands, not where your fear or social media claims it stands. That knowledge, that legal competence, is your primary shield against arbitrary, overreaching, and potentially very expensive private regulation.
And here's a final thought for you to mull over as you integrate all this. If the vulnerability stems from the contractual nature of the HOA, Consider the legal difference between two situations. First, a resident who challenges a newly enacted restrictive bylaw amendment the day it is passed, versus a resident who stays silent for 5 years, during which time that restriction is applied to dozens of others, and then they try to challenge it. The law often looks unfavorably upon claims made against established norms, even if those norms were poorly founded to begin with. So how critical is proactive competence? Reading the document, identifying the adoption date, documenting the absence of incidents, to maintaining your legal standing. The cheapest form of legal self-defense is acting immediately and competently before passive consent makes the battle unwinnable.